For today's story, we discuss when the police can search items you had on your person, but after you're already in handcuffs. Hi, everyone, and welcome to One Civil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this educational content, and today will be the day I earn your subscription. For today's coverage, we're discussing United States of America versus Anthony Buster, also known as Blue Brown Harlem. Blue Brown Harlem here was discovered by the police, and he was wearing basically a fanny pack. The police put him under arrest, and then they searched the fanny pack. So the question is, can they use what they found in the fanny pack at trial against him? Let's get started with this. At 11:18 p.m. on September the 22nd of 2019, two officers in a patrol car approached Anthony Buster as he walked along Fairfield Avenue in Richmond, Virginia. About 30 minutes earlier, the officers had responded to a report of a domestic assault where a firearm was discharged in the air and had been looking for the assailant ever since. The officers approached Buster for two reasons. They believe he matched witnesses' descriptions of the assailant and that he was the person that they had seen outside the victim's apartment earlier in that evening. After getting out of the patrol car, one officer said, "Yo, let me talk to you real quick," and motioned for Buster to come over. Buster said, "Nah," and continued walking. Now, right away, I like this guy, right? Because it's like, let me talk to you, and he's like, nah, right? Because he's not under arrest. Right? So it's like, come over here and have a voluntary conversation. He's like, nah, and just keeps walking, man. Buster has a small place in my heart for this. Despite his many transgressions, a little bit of warmness from a lawyer who's like, nah, just keep walking. That's pretty badass. Okay, the same officer said, "Yo, hey," and continued towards Buster. At that point, Buster took off running, but tripped and fell almost immediately. Not a great day for Buster. The officers caught up with Buster while he was still on the ground and tackled him. Buster was wearing a single strap bag that goes across your body, whose pouch had ended up in front of Buster when he fell. Perceiving that Buster was clutching or reaching for the bag, the officers pulled Buster's arm away from the bag, pulled the bag towards the rear of Buster's body, and handcuffed him. Buster said the bag strap was choking on him, so one of the officers cut the strap, grabbed the bag, and removed it from Buster's person. The bag felt hard to the touch, which in the officer's experience indicates a weapon. The officer opened the bag and found a gun and a box of ammunition. All right, so it looks like Buster may be, in fact, the person that we're looking for. Right? We found this bag on him, and we found a gun and found some ammunition. And also, we saw him hanging around the apartment complex earlier. He might be the guy we're looking for. But the question is, hey, wait a second. When we looked inside that bag, were we allowed to do that? So let's let the Court of Appeals describe a little bit more. The officers also peppered Buster with questions without giving him the familiar Miranda warnings, which incidentally have to be given anytime you're in custodial interrogation. So the question is twofold. Are the police asking you questions? And second, are you in custody? Now, interestingly enough, you can get into some nuance on whether or not being handcuffed is necessarily enough to put you in custody, but I think under these circumstances, probably so. So that means that Miranda should be given, but they didn't do that. After discovering additional ammunition in Buster's pants pocket, an officer asked Buster if he had anything else on his person. Buster responded that the only items he had were that gun and my knife. The officers took Buster to the police station where they asked more questions. Eventually, an officer realized he had neglected to read Buster his Miranda rights, and left the room. About 10 minutes later, the officer came back, gave Buster the Miranda warning, and elicited essentially the same material discussed in the pre-Miranda interview. Yeah, you can't do that. You can't do that. There's much case law on this point, right? You can't solicit all the stuff without Miranda and then give Miranda and solicit it again. That doesn't work. You can't do that. So your attempt to cure your lack of Miranda, not so much, no. Buster was charged with one count of possessing a firearm after having been convicted of a felony. Soon after, he filed motion to suppress the firearm, the ammunition, and his various statements have been in violation of Fourth and Fifth Amendments. The district court held a hearing where the officers testified and video from their body-worn cameras was admitted. So another circumstance in which body-worn cameras provide at least some kind of objective evidence, right? Which is nice for both sides, theoretically, right? Because it will tell the truth, as I'm sure the police officers would have done without the body cameras. But now the body cameras are only here to confirm the truth they otherwise would have said, right? Okay. The district court granted Buster's motion in part and denied it in part. By then, the government had agreed it would not seek to use many of the pre-Miranda statements, making them moot the request to suppress them. The court granted Buster's request to suppress his post-Miranda statements, concluding that they were a product of an impermissible two-step interview tactic and thus barred by Missouri versus Sherbert, United States Supreme Court. It sure is. It sure is. Yeah, you can't do that. So all the pre-Miranda stuff is pre-Miranda, and all the post-Miranda stuff is impermissible because it's part of this two-step thing. So, no. The district court denied Buster's motion to suppress in all other respects. The court concluded the initial stop was valid because officers had reasonable suspicion that Buster was the suspect in a reported domestic assault incident potentially involving a gun, and the pat-down of Buster's person and the search of his bag were reasonable because the officers had reason to believe they were dealing with an armed and dangerous person. The court also declined to suppress Buster's on-the-scene statement referencing the already discovered firearm, concluding it fell within the public safety exception of New York versus Quarles, which incidentally is an exception to Miranda. If this is like the classic ticking bomb scenario kind of thing, like if they need to know something right now for the purposes of public safety, they don't have to give you a Miranda first. So that's an exception to Miranda. So if they're like, where's the bomb? Where's the gun? Where's the kid? For like a kidnapping thing, right? Then that you don't need to give Miranda for that first. That's the idea, right? That the police were asking these questions because of public safety exception, so it fell into that. According to district court, let's analyze it further. Before turning to the merits of the appeal, we must address the government's assertion that we're powerless to do so. We disagree. The general rule is that a validly guilty plea waives all non-jurisdictional defects in the proceeding conducted prior to the entry of appeal. Since 1983, however, the federal rules of criminal procedure have codified a practice known as a conditional guilty plea, allowing some defendants to enter a plea of guilty while preserving certain pretrial issues for appeal. A defendant may enter a conditional plea of guilty, or nolle contendere, reserving in writing the right to have an appellate court review an adverse determination of a specific pretrial motion. So yeah, you can plead guilty with the option to appeal this specific issue. And then, of course, if you win, then you win, and the plea will be reversed. So that's an option. Because suppression of relevant evidence is always a last resort, not a first impulse, if officers have probable cause to leave a particular place or item contains contraband or evidence of a crime, they can get a warrant to search it. In addition, officers who make a lawful arrest may conduct a warrantless search of an arrestee's person and the area within his immediate control as an incident to that arrest, and may later conduct an inventory search of the arrestee's possessions so long as it's done according to standardized criteria such as uniform police department policy and is performed in good faith. The government may also argue that evidence gathered in an otherwise unreasonable search would have been ultimately or inevitably discovered by lawful means, including a search incident to arrest or an inventory search. Here, however, the district court identified only one basis for denying Buster's motion to suppress the firearm found during the bag, and the government has not offered any other. Okay, so this is basically the problem of you use it or you lose it, right? There are multiple different theories that are possibly available as to why this evidence might be admissible in this circumstance, right? But the government, in their infinite wisdom, only identified one reason. And the district court, in their infinite wisdom, only identified one reason. So all the other possible reasons are gone now, right? You lost all those reasons because some of those reasons would seem to apply to this situation. But unfortunately, none of those are preserved, so the appellate court can't consider them. We can only consider the one that you went with. So let's see if that one will save the day. Specifically, the district court concluded that the search of Buster's bag was constitutionally reasonable under the protective search doctrine associated with Terry. On the facts of this case, we respectfully disagree. Yeah. Indeed, Terry itself stands for the proposition that such searches may be lawfully conducted as part of an investigatory stop only when reasonably concludes, in the light of experience, that persons with whom he's dealing may be armed and presently dangerous. Uh-oh. Remember, because he's in handcuffs by the time they look in the bag? Uh-oh. In arguing the contrary, the government relies on the searching officer's testimony that when she removed the bag from Buster's body, she noticed it was hard to touch, which in her experience indicates a weapon. But even assuming officers had reasonable suspicion the bag contained a weapon, a point we need not decide, the fact alone could not generate reasonable suspicion that Buster was presently dangerous after he was already restrained and no longer had access to the bag. That leaves us only with issues of remedy. Although the government argues that any error in denying Buster's motion to suppress his on-the-scene statement about firearms would have been harmless, it makes no such claim about the district court's failure to suppress the firearm itself. The government's silence on this point makes sense given the circumstances of the case, when the underlying charge is predicated on Buster possessing a firearm which we now must hold is suppressed. For that reason, we must not now address whether, and if how, harmless error analysis in the context of a conditional guilty plea, because that issue wasn't raised on appeal, right? So it could have been accepted for some other reason, but unfortunately those issues weren't preserved. So, we can't analyze them. So, yeah. The government's motion to vacate the guilty plea and remand for further proceedings without reaching the merits is denied. The district court's order denying Buster's motion to suppress the firearm is reversed, the judgment of conviction is vacated, and the case is remanded for further proceedings consistent with this opinion. Thus, that brings us to the end of the consideration of United States of America versus Anthony Buster. In this case, we learn that Mr. Buster is a lucky guy, because the United States government dropped the ball, as they sometimes do. And this is one of those situations, right? The police probably could have gotten this evidence admitted under some alternate theory. Unfortunately, the theory the government went with was, well, this was a search incident to Terry. But Terry only allows for searches in order to prevent safety concerns for a person who presently is posing a safety risk. But this person's in handcuffs, so they can't, get to the bag. Also, at this point, incidentally, the bag had been taken off them by a knife, and the bag was like several feet away, because remember, he said it was choking him, so the police, tore the bag off. They cut the bag loose and threw it to the side. So that's also a problem. It's in a closed bag, and he's handcuffed. Now, they probably could have gone there some other way, but Terry, no, they can't. So, yeah, that means that the gun is suppressed. And, his plea is vacated, and with no gun anymore, I don't know where we're going, but at least for the moment, that brings us to the end of consideration of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.